The document was dated March 9th. Eleanor Voss signed it, according to the signature on the page, at 2:14 in the afternoon, authorizing the transfer of her home, her savings account, and the remainder of her estate to her eldest son, Daniel. Eleanor Voss was in the ICU at St. Benedict's Hospital on March 9th. She had been unconscious since March 7th. She did not sign anything on March 9th. She did not sign anything on March 8th. She did not sign anything ever again, because Eleanor Voss died on March 11th at 4:37 in the morning, with her youngest daughter holding her hand and her eldest son nowhere in the building. He was at a notary's office 3 miles away, with a document that bore his mother's name and a pen he had used himself. And the notary who stamped that document was sitting in the third row of my courtroom on the morning of April 22nd. She had not been subpoenaed. She had come on her own. That is where this story begins. I want you to understand something about the crime of forgery before I tell you what happened in my courtroom. Not the legal definition, the human one. Forgery, when it is committed against a dying person, is not primarily a financial crime. It is a crime of timing. It requires the perpetrator to look at someone they have known their entire life, someone who is running out of days, and make a calculation. How much time does she have left, and how do I move faster than her death? That calculation requires a specific kind of coldness, not the explosive coldness of rage, the quiet, administrative coldness of someone who has already grieved the relationship and is now managing the asset. Daniel Voss was 54 years old. He had 2 siblings, a younger sister named Patricia, 49, and a younger brother named Carl, 46. Their mother, Eleanor, had spent 38 years in the house on Maywood Drive, a pale yellow 2-story with a garden she had maintained herself until her knees made it impossible, and then maintained through Carl, who drove over every Saturday morning to cut the grass because she had asked him to and because he liked doing it. Eleanor had been diagnosed with late-stage pancreatic cancer in January. She had been told in February that she had between 2 and 4 months. She had spent March trying to get her affairs in order, which is what people do when they have been given a number and choose to spend that number deliberately. She had told Patricia, in a phone call Patricia had saved and would later submit as evidence, that she intended to divide everything equally among her 3 children: the house, the savings, the small investment account her late husband had started in 1987 and she had never touched because it felt like touching him. Equal thirds. That is what Eleanor Voss wanted. Daniel Voss wanted something different. On the morning of March 7th, Eleanor Voss was admitted to the ICU at St. Benedict's Hospital following a rapid deterioration in her condition. She lost consciousness that afternoon. Her doctors told the family that evening that she was unlikely to regain it. Patricia and Carl took turns at the hospital. They slept in the waiting room chairs. They brought each other coffee from the machine down the hall that dispensed something that tasted approximately like coffee if you had not had real coffee recently. They held their mother's hand in shifts. Daniel visited once, on the evening of March 7th, for approximately 40 minutes. He spoke to the attending physician. He looked at his mother in the bed. He left at 8:22 p.m., which the hospital's visitor log confirmed because hospitals log everything, and that log would become Exhibit 3. He did not return on March 8th. On March 9th at 2:14 p.m., while his mother lay unconscious in a hospital bed 3 miles away, Daniel Voss sat across a desk from a notary public named Sandra Cho and presented a document for notarization. The document was a transfer of estate authorization, handwritten on a standard legal form, bearing what he represented as his mother's signature. Sandra Cho was 34 years old. She had been a licensed notary for 6 years. She had a small office on the 2nd floor of a professional building on Garfield Avenue, above a dental practice, next to an accountant she sometimes had lunch with on Fridays. Her job, in that moment, was to verify that the signature on the document belonged to the person whose name it bore, not to take the presenter's word for it, to verify. She did not verify. She would spend the following 6 weeks unable to sleep properly, and on the morning of April 22nd, she would walk into my courtroom and sit in the 3rd row without being asked, and she would wait. But I am getting ahead of myself. Daniel Voss left Sandra Cho's office at 2:41 p.m. on March 9th with a notarized document. He filed it with the county recorder's office on March 10th. Eleanor Voss died on March 11th. Patricia learned about the document on March 14th when she called the family's estate attorney to begin the probate process and was told that the estate had already been transferred, that there was a notarized document, that the house, the savings account, and the investment account, everything, had been assigned to Daniel 3 days before their mother died. She called Carl. Then she called an attorney named Miriam Osei, who reviewed the document and asked one question before she agreed to take the case. She asked, "Where was your mother on March 9th at 2:14 in the afternoon?" Patricia told her. Miriam Osei said, "Then we have everything we need." Stop right here. I need you to do something before we go any further. Subscribe to this channel and hit the bell notification right now, because what I am about to tell you about what happened in that courtroom, what Sandra Cho did when she walked through those doors, is something I have not seen in 38 years on this bench. Not once. Not in any form close to this. If you leave before we get there, you will miss the only moment in this story that gave me anything close to faith. Subscribe, then come back, because we are not yet at the part that matters most. Daniel Voss arrived at my courtroom on the morning of April 22nd with an attorney named Frederick Bart, who had spent 25 years in estate litigation and who had, in the weeks before this hearing, filed 3 separate motions arguing that the document was valid, that the signature was authentic, and that Patricia and Carl's challenge was motivated by grief-induced confusion rather than genuine legal grounds. He was confident in the way that attorneys are confident when they believe the paperwork is on their side. He had not yet seen who was sitting in the 3rd row. I had. My clerk had pointed her out to me before we began. A young woman, mid-30s, sitting very still in a dark blazer with a leather portfolio on her lap, not speaking to anyone, not checking her phone, just waiting. I noted her. I did not yet know what she intended, but I have been doing this long enough to recognize the specific stillness of someone who has made a decision and is waiting for the right moment to act on it. I called the case. Miriam Osei presented the claim with the precision of someone who had done the work and did not need to embellish it. The hospital admission records for March 7th, the physician's notes documenting Eleanor's loss of consciousness, the visitor log showing Daniel's departure at 8:22 p.m. on March 7th, and his complete absence on March 8th and March 9th. The timestamp on the notarized document, 2:14 p.m., March 9th. The ICU monitoring records showing Eleanor Voss's vital signs and sedation levels at 2:14 p.m. on March 9th. A woman whose hand had not moved in 36 hours. And the phone call, Patricia's saved voicemail from her mother, recorded February 28th, 11 days before the document was signed, in which Eleanor Voss said, in her own voice, clear and deliberate despite the medication, "I want everything split equal, 3 ways. You know that. Tell Carl I said so." The courtroom was quiet when that recording ended. I looked at Daniel Voss. He was looking at his attorney. His attorney was looking at the table. I said, "Mr. Voss, the document in question bears your mother's signature, dated March 9th at 2:14 p.m. The hospital records indicate your mother had been unconscious since the afternoon of March 7th. Can you explain to this court how she signed a document on March 9th? Frederick Bart rose immediately. He said that the hospital records did not conclusively establish that Eleanor was incapable of brief periods of lucidity. He said that family members had reported moments of apparent consciousness. He said the medical record was not determinative. I said, "Mr. Bart, the attending physician's notes for March 9th specifically document your client's mother as unresponsive and sedated at the time this document was purportedly signed. Are you suggesting the physician's contemporaneous notes are inaccurate?" He said, "We are suggesting they do not tell the complete story." I said, "Then I would like to hear Mr. Voss tell it." Daniel Voss was 54 years old, and he had, I suspect, spent the weeks since Patricia filed this challenge constructing a version of events that he had told himself enough times that it had started to feel like memory. This happens. The human capacity for self-deception is extraordinary, and it is most extraordinary in people who need very badly for something to be true. He said, "My mother and I had a conversation in early March. Before she went to the hospital, she told me she wanted me to have the house, that she trusted me to manage the family's affairs. The document reflects that conversation." I said, "The document is dated March 9th. Are you saying the signature was placed on it at a different time?" He said, "I am saying that my mother's wishes were clear to me before she lost consciousness." I said, "Mr. Voss, that is not what I asked you. I asked whether the signature on the document dated March 9th was placed there on March 9th by your mother." A pause. He said, "To the best of my knowledge." I said, "To the best of your knowledge, you are telling this court that you are not certain whether your own mother signed a document you personally brought to a notary's office." His attorney put a hand on his arm. And then the thing happened that I had been watching the third row for since we began. Sandra Cho stood up. She did not raise her hand. She did not call out. She simply stood up from the third row in the gallery with her leather portfolio under her arm, and she said, in a voice that was quiet enough that the entire room had to go still to hear it, "Your Honor, I need to speak." I looked at her. I said, "Who are you?"
She said, "My name is Sandra Cho. I am the notary public who stamped the document in question on March 9th. I am not here because anyone asked me to be. I am here because I have not been able to sleep since I understood what I did, and I need to correct it in the only place where correcting it actually counts." The courtroom went completely still. Daniel Voss turned around slowly. I watched his face move through several things in rapid succession. Recognition, then a particular kind of fear that is different from ordinary fear. The fear of someone watching the specific support beam they had been counting on begin to move. I said, "Ms. Cho, you understand that what you are about to say may have legal consequences for you personally." She said, "Yes, Your Honor, I understand that." I said, "You may approach." She walked to the front of the courtroom with the specific composure of someone who has already calculated the cost of what they are about to do and paid it in advance. In the 6 weeks of sleepless nights between March 9th and April 22nd, she said, "When Mr. Voss came to my office on March 9th, I did not verify the signature. I should have. My job requires me to verify that the person signing is who they say they are, and that they are signing voluntarily and with understanding. I asked Mr. Voss if the signature belonged to the named party. He said yes. I accepted that. I should not have accepted that. I should have required her presence, or at minimum, required identification and confirmation I could independently verify." She paused. She said, "I did not know his mother was in the hospital. I did not know she was unconscious. I stamped a document that I now understand she could not have signed, and I did it because I was not careful enough and because I trusted someone I should not have trusted without verification." She opened her portfolio. She placed a document on the clerk's table. She said, "This is my formal notarial error report, filed with the State Licensing Board this morning before I came here. I have already surrendered my stamp. I am prepared to answer any questions this court has." I looked at Daniel Voss. He was no longer looking at the room. He was looking at the table in front of him with the expression of a man watching something he had built very carefully come apart in a way he had not prepared for, because he had not prepared for Sandra Cho, because he had not considered the possibility that the person who stamped his document would walk into a courtroom and undo it herself.
That is the thing about forgery committed against people who are dying. It requires you to account for everyone who might eventually understand what happened. Daniel Voss had accounted for his siblings, for the estate attorney, for the hospital records. He had not accounted for a 34-year-old notary who could not sleep. I said, "Daniel Voss, this court finds that the document submitted as authorization for estate transfer bearing the date of March 9th is fraudulent. The signature it bears could not have been placed by Eleanor Voss on that date. The notarization is void by the notary's own admission and formal correction. The document has no legal standing. I said, "The estate of Eleanor Voss will be administered according to her documented verbal wishes, recorded February 28th, and consistent with the standard intestate succession laws of this state in the absence of a valid written instrument. The assets will be divided in equal thirds among her 3 children." I said, "Furthermore, I am referring this matter to the district attorney's office with a recommendation for criminal investigation on charges of forgery, fraud, and elder financial abuse. That investigation will proceed independently of these civil findings.
What happens in that process is not within my authority to determine. What is within my authority is to ensure that this court's record is complete, accurate, and available." I looked at him one final time. I said, "Your mother recorded her wishes 11 days before she died. She said she wanted everything split equal, 3 ways. She said to tell Carl she said so. She said it clearly, in her own voice, to the daughter who saved the message because she knew her mother well enough to understand that some things need to be saved." I said, "Eleanor Voss knew who her children were. She made her choice. You made a different one. And the distance between her choice and yours is the distance between who she raised you to be and who you decided to become when you thought no one was watching." I said, "Someone was watching. She walked into this courtroom this morning and sat in the 3rd row and waited for the right moment. The gavel came down. Patricia and Carl sat very still for a moment after the judgment. Then Patricia reached across and took Carl's hand, and they stayed like that for a while without saying anything, the way people stay when the thing they needed to hear has finally been said, and there is nothing left to add to it." Sandra Cho gathered her portfolio from the clerk's table. She did not look at Daniel Voss on her way out. She did not look at Patricia or Carl either. She walked out of the gallery the same way she had walked in, with the composure of someone who has done a hard thing and is not looking for acknowledgement because acknowledgement was never the point. The point was the correction. She had made it in the only place where it counted. I have thought about Sandra Cho every week since April 22nd, not because what she did was dramatic, though it was, but because of what it cost her. She had surrendered her notarial stamp before she walked into my courtroom. Her license, her livelihood, the 6 years she had spent building a small professional practice on the 2nd floor of a building on Garfield Avenue, above the dental practice, next to the accountant she sometimes had lunch with on Fridays. She gave all of that up and walked into a courtroom and said, "I need to correct this in the only place where correcting it actually counts." That is not a small thing. That is everything. If this story stayed with you, if you have ever watched someone treat a dying person's final wishes as an obstacle to be managed rather than a life to be honored, leave a comment right now. Tell me your city. Tell me if you have seen this. Tell me if someone in your family did what Daniel Voss did, or if someone in your family did what Sandra Cho did. Tell me which one you would have been. Subscribe to Courtroom Justice News. Every week I bring you a story from this bench about the moment when the thing someone thought no one would ever find out about walks into a room and sits in the 3rd row. Justice does not always arrive loudly. Sometimes it arrives in a dark blazer with a leather portfolio, sits very still, and waits for the right moment. Eleanor Voss wanted everything split equal, 3 ways. On April 22nd, that is exactly what she got. Courtroom Justice News. The gavel doesn't lie.